All right, looks like audio is going. Make sure there's nothing, no errors or anything like that. All right. So now we're moving into other crimes against persons aside from murder. Start out with, it talks about assault and battery. So historically, assault and battery are used interchangeably. Well, I shouldn't say historically, they're used in together so frequently that they are used interchangeably. There are legal distinctions between the two of them. Your average person won't be aware of it. You know, from a very general standpoint, basically what you need to know is that assault is the threat of violence, battery is actual. So you have that clear distinction there. It says assault could be verbal or actions that threaten said behaviors. Battery would be any time you actually make contact with the person. It's like you know, someone's cussing you out, spits in your face. It's like that's cross that line from assaulting you to battery in most instances. I want to say here though, you have to have that physical touch in that point in time. That's where you cross that line. So historically interchange the two. Common law, kind of general parts to it. Intentionally, knowingly, or recklessly causing bodily injury to another, including person, spouse, that kind of thing. See, threatens another to imminent bodily harm. Intentionally or knowingly causes physical contact with another. So any type, and that it's listed for simple assault. Aggravated assault and battery. Basically start talking about aggravating circumstances. I want to say in one of the previous recordings, I talked a little bit about that, aggravating and mitigating circumstances. Those are facts that when established, either make the crime or the situation worse or better. Whether you're talking about excusing some factor associated with a crime, moving it to a lower level, or enhancing it. For the most part, you're talking about like the presence of weapons, those types of things. Let's see here, immediate versus imminent harm. So being familiar with the difference between those two things. So the big difference between immediate and imminent. Imminent is like incoming. Immediate is, that it could happen, either in the near future or, at some further point in the future. So imminent so basically I'd be thinking about it like, punch has been thrown. You were able to move out of the way. That as the punch is being thrown, that's an imminent harm. As the person's threatening it, that's the threat of future. So let's see, aggravated battery, aggravated assault. Here I also have aggravated battery causes bodily harm, permanent disability, permanent disfigurement. Here in the state of Oklahoma, assault, any willful or unlawful attempt to offer with force or violence to do corporal hurt to another. So there you go, there's the threat. Battery, willful, lawful, and unlawful use of force or violence upon another person. Be mindful of the way that this is written, and if you're not reading in the textbook the cases that are associated with these statutes, because in some instances they'll have cases that will give clarification on some of the finer issues, make sure that you are. Because whenever I put those statutes out, I'm intending for you to read those too. Now here, basically it has Lloyd versus State, basically what it starts talking about there is there's a few things. There's Lloyd versus State, Minks versus State, and when it comes to battery, Steele versus State. So assault, basically, the way it's written here is like you have assault with a deadly weapon as its own separate statute. If you use a weapon with a deadly weapon in that assault, does a jury have to be instructed on assault in general, or is it assault with a deadly weapon statute? Different sets of instructions. We should probably talk a little bit about instructions. I should probably have talked about that in the beginning. One of the very first videos, if I hadn't. With any court case, the jury instructions basically what it will do is it will identify what a juror or the jurors can consider, what they can consider, the decisions they need to make. In the case of criminal law, it's the specific elements of the crime that need to be established in order for a person to be guilty of that crime. There's more than just that, but for the purposes of this conversation, that. So if you are, let's say in this situation, assault with a deadly weapon, they're giving them instructions on assault with deadly weapon, not instructions on assault, meaning they don't have that decision as to whether or not they can find a person just guilty of assault, but only assault with a deadly weapon. Anytime that you have lesser included offenses, basically, I've already said that if you can't establish one of the aspects of the more serious crime, you look at the lower level crime, and that's the one that you'll be more likely to establish. You don't necessarily have to provide those. It's just one of those things that is going to vary case by case and crime by crime. It's like in the last video, I talked a little about murder in the first, murder in the second, manslaughter in the first, manslaughter in the second. So you have a person who, you could have a case where a jury's given the statutes, the elements for each of those crimes, because each one could be a potential lesser offense that a person could be found guilty of if the case doesn't fully meet the burden required for the highest level of crime. Okay. Next thing I need to talk about, Minks versus States delineates assault from battery, and then Steele versus State. Basically, what you're talking about there is when you cross that line from assault to battery, is it how much force, how much violence, how much is needed. And the way that it is here and the way that it is in most places, just any physical contact. So touching of the slightest degree. So you say, I'm going to kill you. And you literally poke the person in the chest, or I'm going to beat your, whatever. And you touch the person in the chest. You cross that line from issuing a threat, assault, into a battery. At that point in time, you've been battered. Okay, assault with battery or assault and battery with a dangerous weapon. There's a statute on that, like I said before. And here it also notes here aggravated assault and battery. So aggravating circumstance here, I'm talking about great bodily injury inflicted, or the disparity in the two persons. Here's what we're talking about: a person of robust health and strength upon who is aged, decrepit, or incapacitated. So a person, if you have that disparity there between the two parties, the aggressor and the person who's injured, you have that huge disparity there. You're looking at aggravated assault just because of the circumstances of it. Mayhem. You probably heard that phrase before. Basically talking about disfigurement, those types of things. You're trying to, or disability are the big things there. When you look at the statute itself, it's got maiming and maiming by disfigurement. So that's the phrase that's used here in Oklahoma. Other states, it may be listed specifically under mayhem. Here, maiming defined: every person who with premeditated design injures another, inflicts upon his person an injury which disfigures his personal appearance, disables any member or organ of his body, or seriously diminishes physical vigor, is guilty of maiming. So serious injuries there. All right. I'll put in here because it's following the the statute on female genital mutilation. That's one. Usually that opens up a conversation about cultural, different cultures, different societies, and what's socially acceptable. So one of the earlier discussions we should have had was related to the fact that law and society are intertwined, in terms that, social changes within a short period of time will change legal standards, and in some instances, legal standards will change society. Those things move back and forth. It's recursive in nature. Basically here, some societies view this as an acceptable and appropriate action to be taken. Here in this country, you can see that it has been outlawed, and it is something that, is criminal, but it is a way that we're, you know, you could say that our society would look to shape that culture in that way. Other places, I mean, different countries, different, whether you're talking different countries or different locations, may not have statutes speak exclusively to this. And in some instances, this, you know, that those actions are taking place in, you know, first world countries because of the fact that there have been cultural changes there. And, you know, there's just a lot to discuss about that. You know, in those places, you know, typically that is performed by someone who is a physician, a doctor, and here, though, it has been made illegal in this state. Okay. Lawful force. I haven't talked about that one. Actually, skipped that one a little bit. So we have a section in there about force against another, not unlawful when self-defense, defense of property. So here's a statute that speaks specifically to that. It's 643. It speaks specifically to defending your own property. It gives different situations where you're talking police officers, those types of things, public officers, rendering aid to another or attempting to prevent an offense to such a person. Again, that's where that discussion about proportionality comes into play. That you know, that it's let's see here. I got notes on it. Let me look back at that because those are going to be more clear. Yeah, officer in the line of duty or during an arrest, self-defense, defense of others. It also has statutes, sections in here that talk about parents and guardians, those types of things, and the authority to use force against children. So there you'd be talking about, I assume spanking, but you could interpret that more broadly than that too. So that's one of those things where, you know, I don't know how I would say that other than say is like, you know, on the scales from when it's lawful and to when you're moving into domestic violence, because that's going to be the other side of that coin. How far those two lines are, hopefully aren't too far. It also has in here about, you know, passenger vehicles like buses, trains, those types of things, when you can use force to eject someone out from those, or those with mental, like you could say, intellectual disabilities, mental disabilities, and the ability to prevent them from harming others, you can use force. Okay. Any other notes here? Okay. Robbery. Now this one's always kind of fun because you learn a little bit more about way crimes are classified and a little bit about reporting. So whenever we have this discussion in class, the first thing I like to ask people is, you know, robbery, is it a crime against person or is it a crime against property? I mean, what's your harm and where is it directed? Is it more directed towards the acquisition of property, or is it because the person's involved? Different states classify it in different ways. Here we follow basically the way the federal government does it and classifies it as a crime against person. Some states classify it as a crime against property. Unless the Arkansas classified as a crime against property, even though people are involved. Basic elements here: trespass, retaking, carrying away of personal property, another with the intent to steal. The carrying away, that's that phrase asportation. Basically, you're moving it, you're transporting it, that kind of thing. Taking away. Also in your home invasion. Some have specific statutes about home invasion. So Oklahoma statute defines it straightforward. Again, robbery is wrongful taking of personal property in the possession of another from his person or immediate presence and against his will, accomplished by means of force or fear. Again, degree of force immaterial and basically fear. Fear here is where they get into a bit better. Just a couple points about fear. Fear of unlawful injury, immediate or future, up to the person or property of another, the person robbed, or any relative of his, member of his family. So threats to you, your family, extended family, that kind of thing. fear of immediate and unlawful injury to the person or property of anyone in the company of the person robbed at the time of the robbery. So anyone, anywhere, if you're there directly, in the direct situation, or family members or those types of things who might not be present. And notice there that it says immediate and not imminent. So meaning that it's not imminent as in taking place, immediate as in could be in the future. Could happen in the next 30 seconds if you don't do it, or it could be I'm going to come back kind of thing. Either one of those is sufficient for it to be classified as robbery. Value of the property is not material. In some locations, the value will matter for what stat for what level it meets, so whether you're talking about robbery or a lower level crime. But here it doesn't. And then it has a section in there about taking secretly is not robbery. So basically, to kind of talk about that one a little bit, the reason that was added in there is because of the fact that there was a case where a person was murdered, and then after the person was murdered, the person who murdered him stole some things from the body. The intent there was to murder. It wasn't a murder that took place in the process of a robbery. Reason why that would matter is because what you start looking at there is well, what type of murder are we dealing with and what type of punishment? If it was a murder in the commission of a robbery, you're going all the way up to murder in the first automatically. If it was a murder and then you just took some stuff after him, you might be talking about second-degree murder, at which point, depending on the specific punishments, you might not be looking at death penalty, or you'd be looking at a lesser punishment in any regard. That's why that's in them. Okay. Degrees of robbery. I won't say that I did. All right. Basically, we start looking at here is the degree of robbery is going to depend on the threat or the harm that it was inflicted. Here, if you're talking serious bodily injury or imminent serious bodily injury, the threat of it, you're looking at first degree. If it's a lesser threat, then you're talking about second degree. Robbery of two more persons, a felony. Yeah. Attempted robbery or robbery with a dangerous weapon or imitation. So basically, that you're talking about. You'd almost classify that as an aggravating circumstance. And the fact that is there, that's going to basically make you fall into a more serious punishment there. Something else I need to talk about. The fear present in a situation or the harm present in a situation has to be presented by the person who's trying to do the taking. If it's not, then it's not. Then it would fall under this. So what I mean by that is that if the harm that is generated in a situation, like let's say someone, you're outside, someone tries to take your purse off you, and you proceed to pull out a nightstick and just beat the crap out of the person. Like that's not going to be robbery, because there was no threat, no violence, no harm that was inflicted by the attacker. Also, whenever you talk about the fear or the actual injury, both don't need to take place. It could be one or the other or both. In any one of those situations. So if you have that threat, that's sufficient. If you have the actual harm, the injury, that's sufficient. You don't need to have both. Okay. Get a drink. Okay, forcible rape and sodomy. So here it gives you some of the common definitions for it. Carnal knowledge of female forcibly and against her will. So elements of that, when it talks about common law, historically it was male-female interactions, specifically fall under rape. Had to be male-female, and it had to include vaginal penetration. So here it notes female gender, so females were the victims, male couldn't be a victim of rape, and but they could be the perpetrator that kind of thing. Penetration wasn't the degree of penetration, just that any took place whatsoever, and that here I mentioned rape by instrumentation. Some states have specific statutes that speak to instruments used. For the most part, that doesn't matter anymore. It allows, this way the statutes are written, they allow for that. And then the lack of consent. So cannot consent if you're under threat or duress. No, nor do some people have the ability to consent in certain situations. So for that, you're talking about like statutory rape situations like that, or intoxication. Any of those scenarios, the person does not have the ability to consent. I'll talk about that, and then I'll talk about rape shield laws. So one of the biggest changes in rape has happened within the last, I want to say it was 2008, but it may have been a different year. So if you start talking about UCR, the Uniform Crime Report, one of the things that they did several years ago was they changed the definition of rape, because the original, what's now termed the legacy definition, aligned more with forcible rape. The current definition focuses in on consent. So in the instance of criminal statutes, the forcible rape didn't always need to have force. Could have been, threat of force, that kind of thing. I'll talk more about that in a second. But consent was a factor. Now consent is the predominant factor, which it should be, but it creates a number of issues that have happened. Well, I shouldn't say have happened, that are more prominent now than what they were beforehand. You can go with the classic. So in class, I start showing different advertisements and things like that. One of my favorite one was it was a poster, and it was about a guy and a girl, Jake and Josie. Jake and Josie go to a party and start drinking. Both get drunk. They have sex. Jake rapes Josie. So it's like Jake and Josie were both intoxicated, yet Josie's the one who was raped because she couldn't consent because of the intoxication. So is that really what took place? So that's unable to be told from that situation. You could have one party, you could have the other party. Both could have been drinking with the intent on having relations, both, and so it not be rape. And so there's a number of issues that pop up with that, because consent is something that should always be verbally stated, but sometimes isn't for people. And so you have to look at the context of the situation, kind of thing, to determine whether or not consent is even possible, and whether it was a factor, the lack thereof. This has led to a number of changes in society, even so much so that it's been a couple of years since I've seen any advertisement for it, but the advent of recorded consent. So one of the things that people have started to do is basically you download an app or make a recording of both you and your partner verbalizing that you consent to engage in said actions, which is good and has its drawbacks as well. For that one, it's well, let's put it this way. I'll give you a real life situation. You may or may not have heard about a woman who's referred to as Mattress Girl. This probably had to be like 6 years ago or more. Female student of a relatively well-known university. Contacts their police department about the fact that she was raped. The reason she's called Mattress Girl was for, I want to say, it was the rest of that semester or the rest of the school year. She carried a mattress around with her to show the fact that she had been raped, to make it up, to basically not let any shadow, not let it be swept under the rug or anything like that. The male who was accused, he was kicked out of school, faced criminal charges, those types of things. When it goes to trial, he presents evidence that she had been sending him text messages asking for him to perform all the said actions she accused him of doing. And at that point in time, what you start looking at is, who's being truthful and who's not. Is it something that was asked for, something that was requested, or something that was forced? Not, I should say forced, but something non-consensual. And that's the biggest problem with recorded consent, because the way those things move forward, it opens up a very dangerous door. Because when it comes to a court of law, what matters more? The fact that you said no, or the fact that they can prove that at some point you said yes. And that's that's the situation with that specific cases. There is no way for us to tell without having much more evidence than is publicly available to determine whether or not she asked for those things, and then later said no before those actions, or even while those actions were taking place, or if it was something that after the fact there was a decision made that to basically use the criminal justice system as a tool against an innocent party. It's like you can't tell from that situation, and that's the danger that's also presented by those recorded consents, is the fact that once you have that recorded, if something happens during the course of that action and a person revokes consent, does the person who has recorded consent have to stop? It's like, well, ideally, hopefully they would, but will they? It's like, not always. And at that point in time, there is no recourse. So there's all kinds of issues associated with it. Usually whenever I talk about this in class, what I start out with is discussing, what is consent? When does it take place? And when can it be revoked? That revocation is an integral part of it, because if it's revoked immediately before, during, or after, then you've moved into this territory of rape. If you have something that establishes that you had it beforehand and there's that change, it's like, again, what's going to stand up in court? The thing that you can prove, or the thing that you say? And it's like that's a very dark discussion to have. Very, very not a good conversation. Also, in terms of general advice, if it's not something you can talk about with the person before it takes place, you probably shouldn't do said action with said person. That's a whole different discussion. So, rape shield laws. So rape shield laws, basically what those do is those are aimed to prevent someone's sexual history from coming into the courtroom when it relates to any type of rape charge. One of probably, I usually have this conversation, not with rape laws, but what I'm going to say, it's one of my first class lessons I usually talk about in person is, if you're going to be in the courtroom, what is it you argue? There's the old phrase, if the facts are in your favor, you argue the facts. If the law is in your favor, you argue the law. And if neither in your favor, you argue character, because that's the whole reason they have character witnesses, is that this person's either such a good person you don't want to convict them, or a person's such a bad person that you must, even if they might not have committed this specific crime. Rape shield laws address that as best as possible. Is they aim to keep sexual history out from that courtroom, so that the jury does not see the victim in a negative fashion and then render their decision based off of that. Because those two things are not, a decision should not be made about one specific action by past behavior that is unrelated. There are still ways to get sexual history in. If this were about arguing said case, we could talk a little bit about some of those ways. But for the most part, they'll do what they can to keep those out. Okay. When you look at the Oklahoma statute, you'll see that it accommodates male, female any type of sexual relationship, whether it's you know, what I'll say, standard. No, that's not the word I'm looking for. You know, same sex or opposite sex, male, female, in any types of those circumstances. And basically, we're talking about there is that see here, also identifies under 16 years of age, inability to give consent, where force or violence are used, if there's intoxicants involved, unconscious, all those types of situations. And it also talks a little bit about, you know, we talk about statutory is built into that. When we talk about forcible, the big change in the way that those cases are looked at, there's been some argument to forcible rape and the change in consent in that, you know, it was easier to prove forcible rape than the lack of consent. Basically what people kind of they put together, but they do it a little bit odd, is the fact that, you know, forcible rape does not necessarily mean that the person is going to show visible bruising and that kind of thing. At the same time, if you have, you know, forcible bruises, those types of things, you know, physical trauma associated with the incident, you know, it's like that is great evidence to have that will help any case that moves forward. And you know, the lack thereof doesn't necessarily would no longer have made it rape back before there was that focusing on consent, because you're still talking about the same issue. It's just you have a much more solid case. Now with the sensitivity towards consent, there's been a good trend towards that focus on whether or not consent was there. And in most cases, when we talk about consent, you're talking about affirmative, not lack thereof. A lack thereof is still not consent. That also is sometimes a point of discussion. Sodomy. So sodomy is so if rape is vaginal, sodomy is anal. So probably the thing that catches you is you can take note of some of the cultural changes that have taken place since this statute was written, because the first sentence there had kind of denotes a negative moral standpoint on the issue. So is there anything else I wanted to really say about that? Yeah, domestic abuse statutes and those types of things have separate, you know, built within them some of the sex-based crimes within those as well too. So I don't think I have those in. Maybe I do have those in here. Yeah, I do. They're further down. So you won't have separate statutes on them within a relationship kind of thing. Sodomy, most people know what that is. Basically, you're talking about, well, that. I don't know if there's anything I want to talk about here besides that. I suppose not. Similar situation. You start looking at consent, those types of things. I want to say that whenever I was looking through the repealed laws related to this, it used to be a crime just to have this act. And I thought I had it in here. Maybe I don't. In some states, you know, it wasn't until relatively recently that you know, the crime of consensual sex that was sodomy in nature was illegal. I want to say that one was in Texas. That if you know, I think it was 2003 all the way up until 2003, that just engaging in that act consensually was its own crime. Okay, domestic violence. A number of different facets fall under domestic violence. You're talking about intimate partner violence, date rape, marital rape, child abuse, child sexual abuse, and then of course just, you know, the regular standards of, you know, child abuse and neglect. I put those statutes in here. When you start looking at them, yeah. So assault and battery, domestic abuse has its own statute. 644, and that there were so many different parts of it. I just basically outlined, you know, what each of those bullet points said after I think I got to I. So I put quite a few of them in there, but it's much longer. So make sure you try to read through all of that. Okay, is there anything you need to say about domestics? I think I'll leave that as that. Most people, you have got a lot of information there to read, so I won't discuss that too heavily. Elder abuse, the way the Oklahoma statute's written is basically starts talking about, well, it builds them all together under vulnerable adults. So you start to, when I say them, abuse, sexual abuse, exploitation, and neglect, all within that one statute. So you'll see that one pop up again when we move into property and talk about elder fraud. Again, abuse can take many forms, whether you're talking about verbal, emotional, physical, sexual, you can say financial kinds of things too. And in recent years, and I don't think our statute talks about that so much now. There have been arguments that economic abuse is something that takes place that depending on the nature of the relationship, if you're talking about husband, wife, that kind of thing, that you know, if one person control the finances, you could be talking about economic abuse. That's nowhere near the same types of territory as what we're talking about in terms of actual abuse, you know, the physical, the violent, sexual, those types of natures, or the physical, well, actually, I already said physical, the emotional kinds of stuff. Okay. False imprisonment and kidnapping. Okay, so kidnapping, restricting the freedom of a victim against his or her will, removing the victim and moving the victim from one place to another. Again, that's the asportation element where you're moving someone. False imprisonment doesn't have that asportation aspect. So I put in the statute about kidnapping, and you'll see here that any person who without lawful authority seizes, confines, inveigles, decoys, kidnaps, abducts, or carries away another with intent to either, you know, keep the person confined or sent out of the state against their will, or held to be sold as a slave, or in any other, or held in any other way, service against the will of such a person. You know, so basically here what you're talking about is not just your classic kidnapping, or trafficking to some degree too, but also you know, making someone, forcing them into work. That could be any forms of work. Notice there that there's a little bit of the age there. You start talking about slavery kind of thing, not classic slavery, but holding the person to work and work that they would not otherwise do. Yeah. Forcing people to work against their will. I thought that one was kind of interesting because I hadn't seen that in a kidnapping statute before. Only in a couple states that I'm familiar with the statutes on. And I'm actually getting more familiar with this states because I just moved here in August. So I'm a relatively new transplant. Okay. Kidnapping for the purpose of extortion. Also have holding people hostage, human trafficking, those statutes. I just gave the list for those rather than all of the elements for it. Hate crimes. So typically, and I put in there a little bit about some of the federal level stuff. And when we move into, I think I started doing property, and I can't remember if I did it in moving into crimes against the public. Some of the federal level stuff too, because you need to know some of that as well. Hate crimes tend to be more of a modifying factor, a factor that you know, enhances a specific crime because it's based on one's, you know, immutable characteristics. What you're talking about, nationality, origin, ethnicity, race, those types of things. The way it's listed in the Oklahoma statutes, race, color, religion, ancestry, national origin, or disability. But if you notice the hate crime that I listed at the federal level, it was one about sexual orientation. So that's typically included, though it's not always specifically outlined. And that's sort of an ongoing, maybe I shouldn't say ongoing, an issue you'll see prevalent in a number of different ways. For example, sexual orientation and those types of things tend not to be listed in areas where they're talking about immutable characteristics for some reason. The last one I saw that was related to that was related to what was it? It was the Hiring practices. Hiring practices is another one where if you start looking at the characteristics to which you can't discriminate employees on, sexual orientation isn't explicitly listed, though it is interpreted in the way that it is included. So ideally you have it listed, but not always. So stalking. So intentionally or recklessly engaging in course conduct that is targeted at a specific person will cause a reasonable person, circumstances of the target person, fear for safety of immediate family, or that kind of thing. All right. So I put in here a little note about cyber stalking because that's one of those things that's a little harder to detect. Though there are movements in that. There are some places that put statutes for it. Our state does not yet have cyber stalking statutes on it, but I would anticipate that to happen before, before too many more years elapse. All right, so Oklahoma statute stalking penalties. Any person who willfully, maliciously, repeatedly follows or harasses another person in a manner that, again, you start talking about intimidation, threatened, harassed, or molested, feel frightened, those types of things. And it goes into many other aspects as well. So note that it kind of has an overlap with harassment. I was actually surprised I didn't find any specific harassment statutes other than by telephone kind of thing, harassing communications. I have a section here on bullying. Some states have statutes on bullying specifically. I did not see that in the state though. So you've got some information on that as well. All right, and I will call a lid on this recording. Hope you guys are having a great one.